Good afternoon, everybody. I am Mark Knoth. I want to thank you for your interest in the topic and thank you for attending today. There's quite a bit to cover. This is a very complicated subject, the reductions in force. Of course, COVID-19 makes it even more complicated, but it will be somewhat fast moving. I also hope that obviously if you're attending, you may be contemplating a reduction in force or reorganization in your organization. Hopefully, this will help you spot the issues and assist you in planning going forward. But again, as I say, it is a complicated process. I've been an employment lawyer this is my 28th year. I tell people that every year there's something else that comes up that's more and more interesting. But this year, for sure, is one of the most unique years. And I like to say that as an employment lawyer, it's the best of times and the worst of times, to quote Dickens, simply because, beginning this year with all the laws and regulations that were passed, and then dealing with employers with positive COVID cases and getting into compliance, it has been unbelievable from a legal perspective, just keeping up and advising and helping clients, and I really enjoy doing that. So with that, I want to get into our topic. As a result of the global pandemic, obviously, some businesses have been severely impacted, some more than others. Some industries have been more impacted than others. Some businesses are doing much better, but unfortunately, quite a few are doing a lot worse. Since the pandemic began, we have seen hiring freezes, furloughs, layoffs, wage reductions, reductions in hours of operations, other cost-cutting measures, I'm probably not even thinking of here right now. But when cost-cutting measures aren't sufficient, and sales are down, and people aren't busy, the next logical choice may be a reduction in force, may be unavoidable. Let's take a look quickly at this document that I have here from a website called Visual Capitalist. And if you haven't heard of it, it's a pretty fascinating website. Every few days they have some other infographic, just about all topics you can't imagine. But this one really caught my eye, particularly because it relates to financial activity between January 4th of 2000 and September 25th. And this shows the percent change in the number of small businesses open. And focusing on our good old Detroit there, some of you may be located elsewhere, but I was astounded to see that there are 28% fewer businesses open. Does that mean that 20% fewer employees are working? Does it mean that sales are down 28%? Of course, industries, different sectors of industry are different, but I thought that number was pretty astounding. Along with this slide, I want to share, just to show the impact of the pandemic, the percent change in small business revenue. The red line represents leisure and hospitality, which of course has been very hard hit by the pandemic. But the blue line shows that revenues for small business are down 21%. To me, that means that unless a company is not taking steps to cut costs, and they haven't been successful, they may be in need of a reduction in headcount, a reduction in force, and possibly a reorganization. Obviously, industries like retail, hospitality, travel, and financial have been hit pretty hard. Every couple of days, I see in the newspaper that larger companies, some of the very large Fortune 500 companies, are doing cutbacks. And in my experience, it's only a matter of time before that type of an approach begins to trickle down. So I thought this topic was very timely. On the positive side, here in Detroit, we do represent a number of auto suppliers, and I should have mentioned that Kerr Russell is a business law firm, or a full-service business law firm, can pretty much handle any need of the business. but we represent a fair number of auto suppliers and those supporting auto suppliers, and we haven't seen such a drastic response to the pandemic. Many of those folks are back to work, and in fact, a lot of the trouble they're experiencing is not finding enough workers. So it is a mixed bag. Stimulus has helped. Maybe some of you on the webinar have received stimulus. That stimulus is running out. Sales maybe have or haven't picked up. We don't know where stimulus is headed. We should hopefully know here in the next couple of weeks, and potentially they're meeting now to talk about it. The big question is that we don't know is whether the stimulus is going to benefit more the individual, or if there'll be another chunk of support for business and small business, medium-sized businesses. In my career, I have worked with companies and done over 100 reductions in force of various sizes, some very large, some smaller than others. There were a fair number of them in the late 90s. 2008 obviously resulted in significant cutbacks. Occasionally, a reduction in force becomes necessary because someone loses a contract or loses business. But this year, you know, I've done probably 3 or 4 so far, and I always hate dusting off, you know, my documents and getting ready to help clients out, because it usually means they're in distress. You know, the keys are really, what do you need to do to get ready to conduct a reduction in force? The keys are, you know, proper planning, good communication with employees about what's happening, and of course about any kind of severance that might be offered. You know, important to really think about selections, good documents, and it's all important because a poorly done RIF, reduction in force, and I'll refer to it as a RIF throughout this presentation, can result in liability. Plaintiffs' attorneys look for mistakes and reductions in force, and they capitalize on them. So questions you need to ask before implementing a reduction in force. Why are you doing a RIF? Why is it necessary? It may be an obvious question to you as you think about it, as you're planning for it, but I think it's important for an employer to be able to articulate those reasons, either with financial records or something of that nature. That is your defense. That is your basis for termination. Just like any other employment termination, you always have to have a good reason. This is your reason, so it needs to be supported. You should be thinking about what areas of your business will be affected by the layoff. Is it a department? Is it a facility? Is it the whole company? Because that can have a great impact on reduction in force design, and that needs to be decided up front. What are the criteria that are going to be used for selecting employees for involuntary layoff? It's important to have criteria set and some standards for how those selections are to be made, because that's essentially where the rubber meets the road. What happens? Can you support the selection decision? In addition to just the RIF decision, can you support the individual employee termination decisions? Looking at number 4, is the severance package going to be offered? You know, not everybody has the money or the wherewithal to offer a severance package. And if a severance is going to be offered, what sort of package of benefits are going to be given to employees if they sign off? You know, given the risk associated with reductions in force, we recommend attempting to do a severance. Really, the critical question is, what is the amount of severance that will convince employees to sign off and not take their chances with a lawyer? Other things to consider: are the employees affected members of the union? If there is a union involved, you know, there has to be some discussion with the union. Otherwise, unfair labor practices can result, depending on contract language. Next question: is the WARN notice required? WARN is a very complicated statute. There are many measurements that need to be taken to determine whether there is coverage. So that's something that needs to be thought about up front. And it also can go into how you conduct the RIF. Maybe you want to conduct a RIF such that it doesn't trigger WARN notice. Are there employment agreements? Are there individual employment agreements? Not so much in the U.S. Foreign employers a lot of times have employment agreements. Most employees are at will here, but if there's an employment agreement with just cause guarantees, and a selection of an employee with one of those guarantees could cause some problems. There could be money owed under the agreement. How will we treat persons who are off on leaves of absence? There are all sorts of reasons a person might not be at work but might have job rights. That is something that needs to be considered. And then the big question is, will the layoff have a statistically significant adverse impact on the protected groups of employees? We're going to delve pretty deep into that question in this presentation, but that is really very important. Statistical analysis is very important in reductions in force. I took statistics in college and thought I would never use it again, but it turns out you have to have a working knowledge of what statistics are and how they play into decision making. Let's talk about some of the common mistakes when conducting a layoff. We've already talked about some of these. Employment contracts. Does somebody have a just cause contract that guarantees them they won't be terminated without just cause? Now, a reduction in force or severe financial distress could constitute just cause. There's case law to support that. But not every reduction in force is because of severe distress of the company. So that's something to consider. Typically, high executives are involved in that situation. Do they have rights under employment policies? Most employers have signed at-will statements and handbooks, so that pretty much eliminates the wrongful discharge claim, at least in Michigan, under a case called Toussaint. It's a presumed just cause relationship can be created, but that's nonetheless something to think about. Collective bargaining agreements, we've already touched on. Almost every contract I've seen speaks and guarantees just cause for termination. Some collective bargaining agreements dictate how layoffs are to occur, and there may be effects bargaining that's necessary. If you work directly with employees for individual contracts and they're represented by a union and the union has not been involved in the process or approved of the severance package, that can be considered direct dealing and could be the basis for an unfair labor practice. Sometimes contracts and collective bargaining agreements waive the right to discuss severance terminations. That may be in a management rights clause. That needs to be carefully examined. But at the very minimum, when I do reductions in force for represented employees by unions, it's always important to have a negotiation with the union, have them buy off on the terms of the agreement, and even have them execute a letter agreement, which I attach to the severance agreement, so that there's a defense against a claim of direct dealing and an unfair labor practice charge. So those of you with unionized workers need to carefully consider the contract. Is there a severance policy? Usually larger employees have severance policies. Severance policies may guarantee what employees receive, but certainly that's something to consider. Sometimes severance policies can get in the way. Maybe you want to terminate an employee that you don't want to give a severance to, and they may qualify. So there are reasons to have a severance policy and reasons not to have a severance policy, but it's certainly something to consider and can be something that's overlooked in a reduction in force. Okay, layoffs may violate applicable laws. So we already I referenced it in the initial discussion, but there are laws that protect employees during leaves of absence. Just to name a few: FMLA, somebody's on disability leave, someone's on maternity leave, someone's got an on-the-job injury and they're on leave for workers' comp. There may be military leave. All those employees have some sort of a right under the statute that they will not be retaliated against for taking that leave. So typically you would have to defend against a case like that to say, look, we had a reason to terminate the employee during their leave. A lot of times companies will leave those employees off to the side until their leave ends and until they return to work. If the reduction in force can't be supported, that can be the basis for a claim. Why was that employee selected? And if we can't explain why that employee was selected over another employee, they'll be able to make the argument that it was because of their leave. So that's something that we see very often in litigation. The FMLA Act specifically refers to circumstances that could lead to the termination of leave, but ultimately a company has to be able to establish that the person would have been laid off regardless of whether or not they were on leave. Layoff of whistleblowers for many of the same reasons. If somebody has reported violation of the law or even complained about sexual harassment, something of that nature, complained about, if it's a publicly traded company, Sarbanes-Oxley Act may protect those employees. And similar to employees on leave, we need to be able to sustain the termination decision. There are claims under ERISA for laying off employees if that layoff is done to preclude the employee from vesting in or attaining benefit rights. That's not a claim we see very often, but it does exist. Usually it's the type of case where somebody's about to vest in a much larger kicker for a pension or something of that nature, and they're terminated as part of a RIF or otherwise. So the big issue are discriminatory layoff decisions, a great area of litigation where it relates to reductions in force. Of course, there's an alphabet soup of state and federal laws that protect many different classifications. Age, obviously a big one, race, a big one in a reduction in force, as well as sex, but of course, religion, national origin, disability, and now LGBTQ, at least at the federal level and potentially very soon in Michigan, are categories that need to be thought about in reducing workforce. Now, what do the cases look like? Let's say somebody gets laid off as part of a RIF and they're in a protected category. They can bring one of two different types of lawsuits. One is called a disparate impact case. We don't see disparate impact cases very often, but they can fit pretty well into a reduction in force claim. What it is where a reduction in force occurs that has an adverse impact on the protected group of employees. Even though the reduction in force wasn't intended and on its face, it doesn't appear to focus on any one group or protected class, statistical analysis can show that an adverse impact exists, and we'll get more into that in a second, but that's one type of claim. The other one is the one that probably most of you are familiar with, the disparate treatment claim, where an individual claims they've been discriminated against or a decision made about them or their employment is based on their classification. You know, and the typical types of claims for that: age, race, sex, national origin, etc. Let's talk again about disparate impact a little deeper. It's a claim that may be established without real evidence of discriminatory motive. A seemingly neutral procedure has an impact on an employee or a class of employees. Statistical proof is key. Nothing lies like statistics, or there are a bunch of other, quotes about statistics. They're all true, because as much as you may want to study a reduction in force, a plaintiff's lawyer will be able to probably find some minutia of statistical analysis that will show a disparate impact against an employee. So what does it mean to do a statistical analysis? If there is a statistically significant adverse impact on a protected group of employees, the company has a problem and has to establish that there is a job-related reason that is consistent with business necessity that serves as the basis for the disparity, the BFOQ. I have included below the formula for the chi-squared test, and That is one of the tools that can be used for statistical analysis in these cases. There are many other tools, including the Fisher's exact test, and the EEOC originally relied on something called the 80% rule, which is a very rudimentary type of rule. Even if job-related, an employee group or affected employees can have a claim against the employer to say that they could have achieved the same result through different employment practices which have less of an impact on the protected group. For age discrimination claims, the Supreme Court recently said that the standard of a defense is less. An employer only needs to establish that the basis for the decision was reasonable and not necessary. What sort of steps should employers take to avoid disparate impact claims? I have a few, and this is an important part of the presentation. I think a disparate impact analysis of the protected groups needs to be done before the selection decisions. And when I say selections, those are the employees selected for termination as part of a reduction in force, the terminated employees, so the selected employees. This disparate impact analysis is essentially, a statistical analysis of those employees considered for layoff and those actually selected for layoff. The statistical analysis is used to determine whether there is a disparity in the protected group. And if you remember your statistics course, statistics determine whether or not something was by chance. If you would expect a certain number of females, minorities, persons over 40 to be selected based on chance, then there is no statistical disparity. The idea being that you flip a coin, you would expect the coin to be heads a certain percentage of time and tails a certain percentage of time. If you get heads all the time and only one tail, that may show that there is a statistically significant disparity in the coin flipping. So something must be influencing the flipping of coins such that we ended up with all heads and only one tail. And, in standard deviation analysis, 2 or more standard deviations generally demonstrates that there is a disparity in the selections, that it's not a chance selection. So we would expect to select that of our group of people terminated, that we would have several people over 40 and certain number of people under 40. If there's heavily weighted that the people selected for termination are over 40, and that doesn't mesh with the makeup of the workforce from an age perspective, there may be a statistical disparity. So the basic idea of 2 standard deviations is that if you flipped a coin, you would expect the selection result only 5% of the or less of the time. If you flipped a coin and you got all heads, and if you expected that less than 5% of the time based on the analysis, that would suggest that something else besides pure chance is influencing the selections. And 2 standard deviations may be enough for a plaintiff to establish a prima facie case of discrimination. Statistical analysis works best with larger groups. The chi-squared test is one that works best with more than 50 employees or up to 100. There are other tools. As I said, the Fisher's exact works for 20 or under. So it's important that a statistical analysis be done by somebody who understands and uses the correct tool so that the analysis is valid. The statistical analysis should be conducted under attorney-client privilege. So the reason you want to try to do these under attorney-client privilege is so that any poor results are not going to be discoverable. The planning stages of a reduction in force, when you're considering who might be terminated, who might not, you're going to make changes, your discussions about that, you may want to have those discussions confidential and include your attorney in that process. Certainly, the retention of a statistician, the statistician should be retained by the attorney, and the communications should come from the attorney so that the statistician's results will be confidential and not discoverable. Only those results that a company wants to release in the event of litigation would be released. I would also say, as it relates to attorney-client privilege, that communications, between managers should be carefully controlled to avoid, the disclosure of communications that could show some sort of an alternative motive for terminating an employee or selecting an employee as part of the group termination program. Emails are discoverable, text messages are discoverable, even conversations you can be deposed about. So it's very important that steps be taken to protect the process. Additionally, once the statistical analysis is done, if it's done under attorney-client privilege, adjustments can be made to those people that are in and out of the reduction in force. Maybe we're too heavily weighted for females and we need to make some other selection decisions. Maybe there's a minority who is selected and there isn't enough support for that decision. Maybe we want to make a change to that selection. Those are all conversations you should be having with your attorney. Something called a phased reduction in force happens over time, where maybe you do one department, you do the next department, and it may take several months to get through the process. Those can cause some problems from a statistical analysis. You may have to go back and review those several times. Statistical analysis can be conducted on just about any group. It can be an overall analysis, it can be over or under 40, it can be over under 50, over under 55, can be by various protected classifications, by department, by plant. A statistician can be very helpful, as can an attorney, in determining what that analysis needs to look like. But it clearly is more complex than simply doing the gross sum of the terminations versus those selected and not selected for termination. Subgroups of individuals' classifications sometimes make a lot of sense, because in litigation, a plaintiff's attorney may key on that type of an issue. And this sort of folds into the release portion of the discussion, because, as part of a reduction in force, if you want an age waiver, you have to provide the employee with data regarding those employees involved in the reduction in force. Let's talk about disparate treatment cases. I'm trying to run through this a little more quickly because I assume many of you are familiar with it. But it too is an important consideration in a reduction in force. Obviously, the prima facie case is on the board. You got to be a member of a protected class. Person has to be qualified. There has to be an adverse employment action taken, i.e. their selection for termination. And then the plaintiff would have to establish that the company replaced the employee with somebody outside of the protected group. Replaced means just that. If a position is vacant or the position was eliminated, there's not a replacement. If the duties were assumed and absorbed by other existing positions, there's not a replacement. That's a defense for the company. The plaintiff also in the Sixth Circuit needs to show additional, in an age case, additional direct circumstantial or statistical evidence that tends to show that an employee was singled out for impermissible reasons. Did somebody make a comment? Did a manager make a comment? Was the person much more qualified than the person selected? Those types of issues. But a mere age differential in an age case is not sufficient to establish that extra evidence that's required at the fourth step of the prima facie case. If a prima facie case can be established at litigation, that's when the company comes forth and gives its reasons, which is typically the reduction in force. We had a reason to conduct a reduction in force. Well, we were under tough financial circumstances. We lost our contract. We have too many employees. People aren't busy. Whatever the factor is, whatever the reason is, as we talked about, that's one of the questions that you ask yourself. the company needs to be ready to come forward with not just lip service, but support for that. And so if it's a financial situation that is the basis for the RIF, a company needs to be prepared to prove that with financial records. Well, here, these are our numbers. This is what happened to our sales. So those are the kind of things that happen at litigation. Once the company comes forward and says, yeah, we had to do a RIF because of financial circumstances, the plaintiff, their lawyer, can still come forward and attack the company's reasons for selecting the employee. Why did you select my client, they'll ask. You know, maybe there are some problems in the selection of a particular employee. And this is really where most of these RIF cases end up, the individual selection decisions. Are we hiring people at the same time that we're conducting this RIF? That could be a problem. That could be evidence of pretext. Are we really in tough financial condition? Maybe the financial records show otherwise. Did we actually replace the employee, or was there some other person that came in and the job title was changed, but essentially they're doing the same work? That is something a plaintiff's lawyer would look for. Did we not follow our selection criteria? Did we set rules for how the RIF was to proceed, and did we not follow those? You know, is there some bias out there that a manager has that he didn't follow the selection procedures? Are our selection criteria supported? You know, are they real squishy and soft, or are they, you know, more objective and clear? Did we pick someone with poor performance? Did they have a long record with the company? Is the documentation not supporting the basis for the selection? Those are the types of issues that come up at the pretext phase. I had a difficult case years ago, a reduction in force case that went to litigation. It was a case where the employer did a force ranking of the employees that were to be considered for selection as part of the reduction in force. The force ranking was done by a committee at a meeting over a couple of days. People sat around a table. There was a board on the wall. People wrote on the board on giant sheets of paper. There was no real good documentation. Nothing was retained for what the basis for those selection decisions were, which caused all kinds of problems in defending the case. It was a bad case. To further complicate matters, everybody who was selected had an opportunity to bump to another position, another vacant position. So not only were people getting notified of their termination, there were also all sorts of people trying to scramble for open positions. Can cause a very difficult reduction in force. Simple is always better. Indicated here in the slide at pretext that a but-for analysis applies in age cases. So in other words, you know, the standard above, a legitimate non-discriminatory reason, that they have to show that their age was a motivating factor. In age cases, a plaintiff only has to show that but for, well, it's a higher standard, that but for the reason of their age, they would not have been terminated. So that's a unique circumstance for age cases. Steps you can take to avoid disparate treatment problems in a RIF. When I'm involved in selection decisions, I will sit down with the client. We will get a org chart. And in that org chart, we will populate employees by all of their protected classifications and ages. We will compare and look at what is happening with other employees, who has similar skills, who might be able to do the job, who is essentially similarly situated. A careful analysis of those decisions needs to be conducted. And I will push back, well, why are you selecting this employee over 40 over this other employee? And I want the employer to be able to describe the reasons to me, the reasons for that selection decision. If you can't tell your lawyer why you're picking one employee over another, you're going to have a much harder time coming up with a clear, understandable reason in front of a jury in federal or state court. Why did you keep one employee over another? Those are critical questions that need to be answered for every single selection. Be prepared in litigation to produce documentation to support the selection decision. The case I referred to, we had large sheets of paper that I told you about, basically poster board that somebody retained, and we had to rely on those. Not good penmanship, not typed, all crinkled paper. That was our evidence for our selection decision. So don't let that be you. Normally in a reduction in force, you should be using the same selection criteria. It can get a little bit murky as to what the selection criteria are. Typically, the release document, if you decide to offer a release, should include some information about what the selection criteria were. There are good selection criteria and there are bad selection criteria. Some are very defensible. For example, seniority, the most defensible of all. You are terminating the least senior employees. No basis for an age case, and certainly a great defense for any sort of a disparate treatment case. It gets a little more tricky when you're into performance. What kind of performance? Are you going to rely on prior performance reviews? Are all those performance reviews well done? My experience, a lot of times the performance reviews are inadequate for this purpose. That's why a lot of times employers decide to do some sort of a ranking of employees, either a combination of factors that are most important for the position or for the retention. Sometimes maybe employees' attendance is really important. Maybe some sort of a validated test has been administered. Maybe there are objective numbers for sales or performance or errors. Those types of objective criteria would be better than subjective criteria. So subjective criteria would be, teamwork and attitude. Now, everybody has sort of a different opinion about what that might entail. What is a good attitude? What constitutes good teamwork? The more objective the criteria, the more defensible the decision, and the more likely that your reduction in force is going to hold up if you get sued in court. Where a position is being eliminated or absorbed by other workers, I said this already, you shouldn't be seeking to fill a position. Again, that goes directly to pretext. Well, you're firing this guy who's 58 years old, but you just hired a 29-year-old with very similar skills, in a similar department or in the department. That's very bad facts. Avoid allowing employees to transfer to other positions if everybody's not allowed to do so. It shows a sort of a favoritism. Let's say you've got 5 employees that all are in the same job title, job classification. They all report to the same manager. You really like one of them. They really work hard and move ahead, and they go above and beyond, and you want to protect them. But really, if you look at the numbers and the data, they should be the one that's terminated. If you transfer that person prior to the RIF or as part of the RIF, that can be a problem. That can be evidence of a problem. Now, if you go ahead and let everybody transfer, that might be a way to defend and diffuse that kind of an issue. But again, that becomes very complicated and prolongs the period of the RIF. It's important to examine the records of those employees selected for termination to determine whether or not did Sally just file a sexual harassment charge? Was Joe complaining about harassment by his manager? That's the basis for claiming retaliation, that the selection decision was retaliatory. So do yourself a favor and make sure you know whether or not somebody has engaged in protected activity relatively close in time to the reduction in force, if they're going to be a selected employee. If they have done so, maybe you don't want to select that employee for termination. Again, be prepared to document the selection. And I've already said it, be prepared to not terminate people with long service records and poorly documented performance concerns. What about planning a reduction in force? You know, it's an important process, the planning stage. Implementing a hiring freeze. Now, that's not always possible or doesn't always work, but if you can prevent people from being hired while you're reducing headcount, that is a surefire way to avoid trouble in a reduction in force. Said it again, I said it a number of times, I'll say it again, you got to document the reasons for the RIF. In COVID, we would expect that a reduction in force would result in a cost savings, but it's the type of thing where we would have to go through and actually do the math and show, be prepared to show, well, the severance we paid was this. We saved this amount of money. You will be second guessed in litigation if it comes to it. So it's important to have basis for the decision. Establish the selection criteria. Determine what the overriding basis will be for the decisions. Determine who will make the selection decisions. Is it going to be a department head? Is it going to be a supervisor? Or is somebody at a higher level going to make the ultimate decision? That person should be very articulate, be prepared to testify if it ever comes to it, but also keep in mind that the higher up the food chain you go, the broader the RIF could become. So we'll talk about that in a moment or two. You need to select and analyze the employees for termination, compare them as we've already discussed. You need to conduct a statistical analysis of the proposed selection decisions and hopefully make adjustments if there are problems. It's important to determine whether or not WARN applies. WARN, again, is a very complicated statute. And if WARN notice, which requires 60 days advance notice, is required, it may delay the reduction in force. The severance. Is a severance going to be offered? What's it going to be? And then implementing the reduction in force. Many reductions in force go wrong based on communications. I think it's important that a communication plan be put together, that it's a standardized package that is communicated to employees, that employees are met with to disclose that they're going to be terminated or selected, and that managers have talking points and that they stick to those talking points. Standard release, which is a standard package or formula of benefits, should be prepared. And that release is a critical document, because as bad as the reduction in force is and as bad as the selection decisions are, a signed release can solve those problems. But what needs to be in a release document? If a severance is offered, it should be paid in exchange for employees signing a full release of claims with the company. I can't tell you how many times employers have simply paid money out to employees in one form or another and haven't sought a signed release in exchange for that. Anytime you're paying an employee, I think you should be getting a release from that person. Releases should include, these are basic requirements. These are not ADEA requirements, age discrimination waiver requirements. They need a clear description of the parties to the agreement. You may want to include a waiver of individual managers. That should be a personal waiver as well as in their official capacities. A recitation of the benefits, including tax treatment, whether or not, severance benefits, what the tax withholding, whether or not health care is being offered, if that's going to be through COBRA or some other mechanism or a cash payment, may be a savings on taxes. A recitation of the claims being released by the employee. Not absolutely necessary, but very important, I think, to get a recitation of those released claims. In an age waiver, the age statute must be released. We'll talk about that in a moment. In addition to the release of claims, a valid release should have a promise not to sue on the claims being released. there should be an acknowledgement that the employee's been paid everything they're due. An acknowledgement, a factual acknowledgement, because wage claims, overtime claims can't be waived. So I like to have the employee affirm that they've received all the wages they're entitled to. Sometimes I have them affirm that they have experienced no on-the-job injuries. That's another unwaivable claim. I like to get an express waiver of any class action claims, particularly in a RIF, reduction in force. A waiver of any entitlement to monetary relief. So in other words, a person cannot waive their right to go to the EEOC. It's a statutory right that can't be waived, but a person can waive their right to receive monetary relief in response to, some sort of an EEOC action. They can agree not to take any money if the EEOC decides to move forward with some kind of claim. I like to include a promise not to seek reemployment with a company or a placement with the company in the future. Of course, depending on the circumstances of the RIF, you may want to have somebody back, but again, it needs to be a standardized provision. Most releases contain confidentiality, agreements to cooperate with the company if needed, and non-disparagement clauses, which may or may not be good or enforceable depending on the language. Of course, there's other standard contractual language that goes into releases, but those are the big basic terms. There are specific requirements if you intend to obtain a release of federal age discrimination claims under the Age Discrimination in Employment Act in a reduction in force. And of course, I think in many times the age release is one of the most important releases to get in a reduction in force. So who's protected under the ADEA? Employees over the age of 40. There are approximately 10 requirements, specific requirements, to obtain a valid enforceable release under the ADEA, known as the Older Worker Benefit Protection Act. Enforceable age waivers are referred to, in RIF cases, are referred to group termination programs. That's a term that is in the EEOC regulations. What is a group termination program? It's where a termination occurs of 2 or more employees and a standardized package of benefits is offered. Typically, reduction in force is not individualized, doesn't involve employee performance. It's for one of the reasons for the RIF. I sometimes get employers who don't have sufficient documentation for a performance termination to try to call it a reduction in force. That's playing with fire, because if you call it a reduction in force and the reduction in force isn't a real reduction in force, you've sort of forfeited your ability to argue performance. So I run into that sometimes with employers that are a little less sophisticated. It's not a silver bullet, reduction in force. The group of the employees involved in the reduction in force are known as the decisional unit, and that is defined again under the waiver guidelines. The decisional unit is the group of employees, the class of employees, maybe it's the sales department or the finance department, which is being considered. It doesn't mean you're terminating all finance employees, but that is the group of employees that are being looked at for a possible reduction in force. The decisional unit is completely up to the company to create. And that's why the planning phase is so important. Maybe you don't want to provide information about all the employees in the entire workforce. Maybe you want to laser focus it on a particular work group. That's why it's important to establish the decisional unit. And the statistical analysis will likewise focus on the decisional unit. There may be situations where you would like to analyze the entire workforce as the decisional unit. Maybe you're dealing with a group that is poorly represented for a particular group, and opening the reduction in force up to additional departments or groups or facilities may make the statistics look better, but it's still not going to change the individual statistical analysis for that department. Okay, so these are the items that must be included to have an enforceable release under the Age Discrimination Employment Act. And these requirements are absolute, and it's on the employer to prove that they happened in the release. So if these things are not met, you're not going to have an enforceable release. The wording of the written waiver must be understandable to the average person who is participating in the reduction in force. If you've got a 15-page release and you're giving that to, line workers or somebody with a high school education, that might not be an enforceable age waiver. So you have to consider your audience. I have several agreements I use, very simplistic ones and more complicated ones, depending on the groups of employees that are being involved in the reduction in force, or even just a waiver. The waiver has to specifically reference the ADEA. That's a non-starter if it doesn't. The employee must be advised to consult with an attorney. A lot of times that gives companies heartache that they have to have that language in there. But there have been cases where people have tried to get cute with that phrase. If it's not the exact phrase, you may not have an enforceable waiver against an employee's claims. Employees can't waive future rights. Number 4. In this regard, I think it's very important that when conducting the involuntary reduction in force, where employees are being terminated, that the waiver not be effective before the employee stops working. And more specifically, when the employee returns the signed agreement, they should no longer be working, because there could be a time after the release is signed where a claim of discrimination arises. There could be a harassment claim. There could be some other basis for a claim. You always want your employee to stop working because you can't get a future claim. There are mechanisms you can utilize, a 2-release mechanism if you want somebody to accept the release, but you want to keep them on, but those become complicated. You got to provide something to an employee they weren't already entitled to. The example I think of this oftentimes is, vacation benefits. Well, maybe your policy requires the payment of vacation pay, and that's not something they're otherwise not entitled to. They're entitled to that. So if you're going to pay out their vacation and they're already entitled to it, you don't have adequate consideration for the age waiver. Now, the time to consider the waiver. In a group termination setting, employees have to be given up to 45 days to consider the release. For individual terminations, it's 21 days. People always ask what the 21-day thing is. It relates specifically to the Age Discrimination and Employment Act. 45 days is a significant amount of time. Employees can sign in less than 45 days, but we can't offer them some incentive to sign early. So that's an important thing to have essential thing to have in the agreement. The revocation period, once they've returned the signed agreement, they must have 7 days to revoke. They can eliminate their acceptance and their entitlement to the benefits before the end of 7 days. So it's very important that benefits or severance benefits not be paid until that 7-day period is run. This period cannot be shortened. This is unique to reductions in force, the informational requirements, and this goes to the statistical analysis. Every release document needs to have attached to it a chart, which includes the decisional unit of employees, so the universe of employees being considered for termination, not by name, but simply by job title, their age on the date of termination, and whether they've been selected or not selected for termination. This information is supposed to be used by the plaintiff and or his attorney to determine whether or not there was a statistical problem with their selection for termination. Most people who receive a RIF don't understand the documentation, and quite frankly, a lot of employers don't either. There can't be a preclusion of administrative rights going to the EEOC. You can't prevent an employee from going to the EEOC to challenge the waiver. You can't prevent them from filing a charge. You can't prevent them from being a witness or participating in an investigation. A lot of times, even though the regs specifically don't refer to that, those releases will include that type of language. There can't be a penalty, number 10, in the release agreement. And that is typically if somebody sues, they have to give the money back. Those penalties are specifically precluded. There are other penalty provisions, perhaps an attorney fee provision that may or may not constitute a penalty, so I often don't include them. We already talked about it, the importance of compliance. 1 through 10, it's the company's burden. If they want to enforce the release, they have to show that every one of those items was adequately complied with. We're running short on time here pretty quick, but voluntary exit incentives, I wanted to touch on quickly. There are basically severance programs which are voluntary. They can be designed in such a way that those packages are only offered to certain groups of employees, as long as age is not the sole factor in coming up with those employees that will be given that offer. When you do offer a voluntary exit incentive, it can't be under a threat of possible termination. And of course, all the waiver requirements and informational requirements apply to voluntary exit incentives. The last topic I wanted to touch on was the WARN Act. And again, we're running out of time, but again, it's a very confidential. It's a very complicated statute. Requires 60 days advance notice of a plant closing. That means that if you don't provide the notice, the employee is entitled to receive up to 60 days pay, plus benefits, plus attorney fees, plus other potential penalties. Companies can choose simply to pay that instead of giving the notice. And sometimes they do that because a lot of times notifying employees of their impending layoff causes all sorts of morale problems, can cause sabotage of operations and other problems that companies don't want to deal with. So does it apply to you? So the WARN Act applies to employers that have 100 or more employees, excluding part-time employees. And there are a lot of different numbers in this WARN Act, and this is the first one. 100 or more employees. If you don't have 100 and more, it doesn't apply to you. But if you have less than 100, or you have a bunch of part-time employees, and in the aggregate, they average 4,000 hours per week, you are covered. So assuming you're covered, who gets notice? This notice is fairly innocuous, but the form needs to follow the regulatory requirements. Goes to the employee or their union, or both. Goes to the state dislocated worker unit, which is some office in Lansing or whichever state you're in. And it has to, a copy of the letter has to go to the mayor of the town that the facility is located in. What are the triggering events? Permanent or temporary shutdown of a single site, a plant closing or a mass layoff. Those are the two different triggering events. So assuming you have 100 or more, if you have a plant closing, which is a permanent or temporary shutdown of a single site of employment, which results in an employment loss of 50 or more employees. So permanent or temporary is kind of an important question, particularly now during COVID. 6 months is considered a triggering event. If a plant closing is expected to be 6 months or more, then you have a closing that requires more notice. Mass layoff, a little bit different. A reduction in force other than a plant closing of 30 or more days of 1/3 or more of active employees at a facility, or at least 500 employees. So mass layoff really will only come into play with sometimes larger facilities. And these analyses as to plant closing and mass layoff are based on facilities. Gets complicated where companies have facilities in close proximity to one another. There are some exceptions. Temporary layoffs, we already talked about that, the 6 months. Faltering company exception applies only to plant closing, not to mass layoffs. So in other words, plant closings and applies on a company-wide basis. So if you're going to say that you have a faltering, you're in financial distress, they're going to look not only at the facility, they're going to look at the corporate records to determine whether or not, that exception applies. And the big one, and I'll end on this, are the unforeseen business circumstances. Unforeseen business circumstances are sudden, dramatic, and unexpected business circumstances that were not reasonably foreseeable and were outside of the company's control. It sounds like the COVID-19 pandemic, but we aren't certain of that. And the other concern is that even if there is an unforeseen business circumstance, notice is still required as soon as practicable. The Department of Labor has issued some questions and answers regarding COVID and the WARN Act, and they have somewhat punted the ball to suggest that it is determined on a case-by-case basis. Certainly, plaintiffs' lawyers will be looking for failure of WARN notice as a result of the COVID layoffs. It is something to have some concern about. But again, if a release is obtained as part of a reduction in force,